Well, good afternoon, everybody. Thank you all for taking the time. Today's discussion has been entitled Estate Planning and Digital Assets. And this discussion is going to provide everyone with an introduction to an ever-evolving, cutting-edge issue in estate planning, which is how to plan for cryptocurrency and other digital assets. My name is Austin Bertrand, and today I have Wes Hedrick with me. Together, we will briefly touch on the current statutory law in place for digital assets, some key terms and definitions that apply to the cryptocurrency and the blockchain technology space, and a few specific areas to consider when discussing proper planning and drafting with clients. So, when we hear the word assets, most of us probably think of all the stuff that we could own, like a house, or a car, or a bank account, or even your favorite pair of shoes. And in the context of probate and estate administration, we probably expect that an executor of an estate should be able to collect and manage all of the decedent's assets, like a bank account titled in the name of the decedent, or to be able to transfer the decedent's primary residence to the beneficiaries named under the decedent's will. But what about the decedent's digital assets? That is, the decedent's electronic documents, emails, files saved to a cell phone, social media accounts, and other information saved on a personal computer or in the cloud somewhere. Does that same executor have even a duty to administer these items? And does that executor even have sufficient authority to take any action at all?
Fortunately, we have some statutory guidance that has seen various enactments since 2005, the most recent version of which is found in the Revised Uniform Fiduciary Act to Digital Assets, or RFADA for short. RFADA defines digital assets as an electronic record in which an individual has a right or interest. The term does not include an underlying asset or liability unless the asset or liability is itself an electronic record.
That's right. So why should any of us even care about what RFADA has to say? Well, in addition to defining the term digital assets for us, RFADA governs access to a person's online accounts when the account owner dies or that account owner has lost the ability to manage the accounts by extending the traditional power of a fiduciary, like an executor or a trustee, to manage tangible personal property that would also include the management of that person's digital assets. And I should probably also clarify here that when we use the term fiduciaries today, it's going to be used to collectively describe executors, trustees, attorneys in fact under a power of attorney, just for today's lesson. So bearing that in mind, while RFADA allows fiduciaries to manage digital assets like computer files and web domains, RFADA generally restricts a fiduciary's access to electronic communications such as email, text messages, and social media accounts unless the original user consented to fiduciary access in a will, a trust, or some other record. So to put it another way, a fiduciary's authority under RFADA is not absolute, and estate plans must be drafted with this in mind in order to take into consideration which digital assets will and will not be protected under RFADA.
Thanks, Austin. So we now have an idea of what digital assets are, as well as the general law that governs the fiduciary's access to those digital assets. But does any of this apply to cryptocurrencies?
Well, Wes, we should probably talk about cryptocurrencies in general before discussing RFADA's application to cryptocurrency. And just as a heads up to everyone, the technology that propels cryptocurrencies can be highly complex, and it relies on terms that in of themselves can be a barrier to entry just to understand what's being discussed. And we should also disclaim that today's discussion is going to be strictly limited to discussing crypto assets in the estate planning context, and we're not going to be conducting a deep dive into the technology as a whole.
The primary term to understand here is blockchain, which is the underlying technology of cryptocurrencies like Bitcoin, Ethereum, and Litecoin. A blockchain is simply a list of transactions that anyone can view and verify. One use of the blockchain is to track tokens, which is a digital representation of some item, usually an asset, being transacted on a blockchain.
Thanks, Wes. And any asset can be tokenized on the blockchain, which can include intangible assets like a share of stock, or tangible assets like an ounce of gold, and purely digital assets, which is basically how we get to the idea of cryptocurrency. Some tokens are going to be fungible, meaning that each token that is issued is going to be worth the exact same amount, which again is kind of the basis of cryptocurrency.
And alternatively, some tokens are non-fungible, which means each token is unique. Non-fungible tokens, or NFTs, are typically used to authenticate ownership of unique digital assets, such as artwork, tweets, or some other form of digital collectible.
And another thing to remember here is that tokenized crypto assets, such as cryptocurrency and NFTs, are secured through cryptography and stored in uniquely identified digital wallets that cannot be unlocked or read without the proper keys.
To reiterate, it is impossible to break the wallet's cryptography security. So from an estate planning standpoint, and regardless of whether the crypto assets are held directly on the blockchain, through a crypto exchange, or with a financial institution, loss of access to the proper keys will mean loss of the asset forever.
Yes, so hang on to those crypto keys at all costs. So let's turn back to estate planning. And in particular, I think just what we're going to talk about for a moment here is conventional estate planning. And what does that mean? Well, conventionally or traditionally, estate planning is going to rely or has relied on the drafting and implementation of a variety of documents, usually wills or trust agreements. And those documents are utilized to manage and ultimately distribute a decedent's personal property, real property, and other assets. And then upon the decedent's death, a fiduciary may then also, in addition to reviewing those documents, the estate planning documents, they could seek to review the decedent's prior tax returns, physical files, as well as the decedent's incoming mail to ensure that all of the decedent's assets have been inventoried and are going to be properly managed as a part of the estate administration process.
But what happens if the decedent lived a paperless or mostly paperless existence? How does this fiduciary learn about traditional assets that are reflected purely in paperless records? And how does the fiduciary administer purely digital assets such as social media profiles or cryptocurrency?
And this is where RUFADA comes back into play. As we mentioned earlier, the fiduciary's authority under RUFADA is not absolute, but RUFADA does establish a three-tier system under which a deceased user can authorize a fiduciary access to that deceased user's digital accounts or digital assets post-death. The first tier, or we'll just say tier one access, is granted if the user executed what's called an online tool agreement with an internet service provider or ISP. Online tool agreements are separate agreements from the terms of service agreements that are usually in place for those types of digital assets. And these online tool agreements will override any contrary direction by the user in a will, a trust, or some other governing estate planning document.
And tier two access is granted if user included enabling language in their will or trust that specifically authorizes or prohibits the fiduciary to access the user's digital asset information stored on the server of an ISP. In the absence of the first two tiers, then tier three access relies on the provisions of the terms of service agreements that the user signed when the account was created, which in most cases will mean that no access will be permitted to the fiduciary.
So in addition to that, just another fair warning here, relying on RUFADA to provide your fiduciary with access to your crypto assets can be problematic because RUFADA has no mechanism to provide access to cryptocurrencies and NFTs held directly on the blockchain and where there's no custodian that exists for the management of those crypto assets. That being said, some crypto exchanges like Coinbase are not direct blockchain holdings. And consequently, RUFADA may be able to assist a fiduciary in accessing those types of accounts.
And additional pitfalls for the fiduciary exist here as well. Crypto assets are harder to identify and may be invisible on the decedent's prior tax returns, physical files, and incoming mail. This increases the risk to the fiduciary who has a duty to properly manage and administer the decedent's estate. Or a fiduciary may successfully identify and access a crypto asset after spending a significant amount of time, money, and effort only to discover a crypto asset with minimal value.
So before we turn to some more proactive planning ideas, we wanted to highlight a couple of real life situations that resulted in an irrevocable loss of significant crypto assets. In the first example, an individual by the name of Matthew Mellon left behind an estimated $500 million in XRP tokens, which was a type of cryptocurrency at the time of his death. But Mr. Mellon never shared the location of the keys needed to access his digital wallet. And to this day, his family has yet to locate any of that $500 million crypto holding or the keys.
And then another example, which has also been made into a Netflix movie, Gerald Cotton was the only person with access to the passcodes for his crypto exchange, Quadriga CX, and his death resulted in about 250 million in other people's assets being inaccessible. Both of these examples highlight a critical component of estate planning. If your loved ones don't know how to locate or access your assets, those assets will be lost forever.
And as a part of that key takeaway, it's always a good idea to schedule meetings with your estate planning attorney at regular intervals to ensure that your estate planning documents encompass the management and disposition of all your assets. But a part of that discussion, those regular meetings, really needs to touch on how your assets are titled. And in the case of hard to locate or difficult to access assets, that attorney should be a part of that discussion as well, just to prevent some of these irrevocable losses that we just detailed on here.
Some other idea. I'm sorry.
Nope, that's it's all good. I'm going to go ahead and keep running. So how do you properly plan for the post-death management of all of your digital and other crypto assets? Well, while it is going to take some time and attention to detail, you should maintain a secure list of all digital accounts. You should also maintain a list of how to access each of those digital accounts. And you should also maintain a list of the passwords for all digital storage devices. To the extent you're able to do so, you should also establish tier 1 access through online tool agreements that will help provide your fiduciaries with post-death access to your digital accounts and digital assets. Also, you should only use a work email address, assuming you have one, for work-related purposes, and do not use your work email for any storing or accessing any of your personal digital assets or content.
Some other ideas include creating a separate email account for the sole purpose of accessing all personal digital account information and online content. Of course, your estate plan document should be revised to permit Tier 2 access by including language that specifically authorizes fiduciary access to digital asset information. And even the most ardent paperless individuals should request hard copies of annual statements and income tax reporting documents, even though such documents might still be accessed online.
And for your crypto assets that are not covered by Rufata, you will once again want to work with your estate planning attorney to make sure that your estate planning documents have been updated. And in that updating process, steps want to be taken to specifically exclude any blockchain assets or from passing under any gifts of tangible personal property sections under the will or the trust agreement. Basically, you don't want your digital assets to be included with gifts of personal property like clothes or household furniture. You should also ensure that your estate planning documents have updated the definitions article or section to include definitions for blockchain assets. And to the extent you're able to do so, you should also identify any storage device or other tangible personal property which are used to manage blockchain assets, like a cell phone.
And when relying on a revocable trust-based estate plan, all crypto assets must be properly titled as part of that trust in order to avoid probate of those assets. And the provisions addressing the fiduciary's investment powers in both wills and trusts should permit the fiduciary to participate in crypto investments. Finally, you may also want to consider naming a special investment advisor or establishing specific custodial provisions specifically addressing the disposition, investment, and management of crypto assets.
So notwithstanding the aspects of crypto assets and digital assets that can complicate estate planning, these assets can still be a part of any estate plan, which means it's an exciting time to engage in proper wealth planning intended to create wealth for the next generation. And common wealth transfer planning techniques such as charitable donations or the creation and operation of closely held entities and transfers to trust can be based around crypto assets.
And the tax motivated benefits of these planning techniques can be enhanced by crypto assets because of the investment volatility and risk associated with these assets. Asset volatility combined with discounts for lack of marketability and control in the case of entity planning can substantially reduce the valuation of assets that are anticipated to appreciate dramatically over time.
And of course, the complexities involving crypto assets will continue to exist in this space and will probably only become more complex. So careful consideration and regular reviews should be given to selecting a competent estate planning attorney, along with appointing knowledgeable and capable entity managers and fiduciaries.
So we covered a lot of material in a short amount of time today, and we also managed to touch on several key takeaways about estate planning for cryptocurrency and other digital assets. First, the fiduciary's authority over crypto assets is not absolute under RUFADA, and additional planning will be necessary for crypto assets. Second, retaining access to crypto assets is critical not only for yourself, but for your loved ones and appointed fiduciaries. Third, regular meetings with your estate planning attorney are a vital part of ensuring that your estate planning wishes are fulfilled. And fourth, planning for crypto assets requires special consideration of security, structure, and implementation, so advisors and their clients should include managing digital assets in every conversation about estate planning.
Thanks, Wes. And that is all that we have for everybody today. We're very thankful to have spent this time with you all. And if anybody has any questions, we're happy to answer them. Otherwise, we hope everybody has a wonderful Monday as well as the rest of your week. And thank you again for stopping by and listening to today's discussion. We appreciate it.
Thank you.